Hi guys! So welcome to Law Diaries Lex Comentarios. So for today's video, we are going to talk about Article 24 of RPC. Article 24 talks about the measures of prevention or safety which are not considered penalties. So let us read this provision. So muna tayo para masulat ko dyan yung provision. So the following shall not be considered as penalties. Number 1, the arrest and temporary detention of accused persons as well as their detention by reason of insanity or imbecility or illness requiring their confinement in a hospital. Number 2, the commitment of a minor to any of the institutions mentioned in Article 80 and for the purpose of specified therein. Number 3, the suspension from the employment or public office during the trial or in order to institute proceedings. Number 4, fines and other corrective measures which, in the exercise of their administrative or disciplinary powers, superior officials may impose upon their subordinates. And then number 5, the deprivation of rights and the reparation which the civil law may establish in penal form. So, the foregoing measures, guys, yung mga sinabi ko or yung mga na-enumerate under Article 24, guys, are not considered as penalties since these are being resorted to either for purpose of filing a complaint or during the pendency of the criminal action or merely an adjunct to the superior exercise of their administrative prerogatives. So, sa paragraph 1, guys, which talks about arrest and temporary detention, ito yung pag-aresto or pag-detain ng isang accused. Dito, guys, kapag na-arrest or na-detain yung isang tao, guys, this cannot be considered a penalty. So, kapag ang isang tao is na-detain siya or na-aresto siya, it doesn't mean na penalty na yon sa crime na ginawa niya. So, sa paragraph number 1 of Article 24, it contains the above phrase which is as well as their detention by reason of insanity or imbecility. So, this paragraph does not refer to confinement of an insane or imbecile person who has not been arrested for a crime. It refers to accused persons who are detained by reason of insanity or imbecility. The word there in the second clause of paragraph 1 refers to accused person in the first clause. So, dito guys, sa paragraph 1, guys, hindi to tumutukoy dun sa mga tao na na-confine because of insanity or imbecility, but this refers to those accused person, guys, na na-detain for the reason of insanity or imbecility. So, yung there dito, guys, so, as well as their detention by reason of insanity or imbecility, guys, this refers to the accused person. Okay? So, why are they not considered penalties? So, bakit ba itong mga na-enumerate under Article 24 is hindi siya na-considered as penalty? So, they are not penalties, guys, because they are not imposed as the result of judicial proceedings. Meaning, yung pag-detain or pag-arrest ng isang tao, for example, is hindi yun effect or result ng judicial proceedings or yung mga court, yung mga decision ng court, yung ganon-ganon. Those mentioned in paragraphs 1, 3, and 4 are merely preventive measures before conviction of offenders. So, itong sa 1, guys, which talks about arrest and temporary detention sa mga insanity, imbecility, or mga illness. And dito sa paragraph 3, which is suspension from employment or public office during the trial. And then yung number 4, guys, is yung fines or corrective measures. These were merely preventive measures at hindi siya penalties. Or, ito yung mga measures na ginawa before makonvict yung offenders. Ganon. So, the commitment of a minor mentioned in paragraph 2 is not a penalty. Well, dito naman guys, di ba, yung paragraph 1, 3, and 4, hindi siya penalties because they were a preventive measure para sa mga accused person, yung mga ganon, or before the conviction sa offender. Well, dito naman guys, sa paragraph 2, it is not a penalty because it is not imposed by the court in the judgment of the conviction. The imposition of the sentence in such case is suspended. Dito sa paragraph 2, which is the commitment of a minor to any of the institutions mentioned in Article 80, which we will discuss in the future. So, ito guys is hindi rin siya makukonsidered na penalty dahil it is not imposed by the court or hindi mismo yung court yung nag-declare ng ganun sa judgment or of conviction. So, kaya hindi siya penalties. And yung fines naman guys, mentioned in this article should be imposed by the court. So, the fines mentioned in paragraph 4 are not imposed by the court because when imposed by the court, they constitute a penalty. So, bakit again yung fines dito na nakalagay sa paragraph 4 ng Article 24 is hindi siya makukonsidered na penalty? It is because, guys, hindi siya na-impose ng court. Kapag na-impose siya ng court, guys, dun mo lang siya matatawag na penalty. The Commissioner of Civil Service may, on certain ground, fine an employee in an amount not exceeding 6 months' salary. So, yung civil service, hindi naman yung court yung nag-impose ng penalties na, ng fines na yun. So, hindi siya makukonsidered na penalties. So, again guys, a measure or a sanction can be considered a penalty only if it is inflicted or imposed by virtue of a final judgment in the instances mentioned in this provision. There is no final judgment yet. So, again, paulit-ulit guys, yung mga na-mention under dito sa Article 24 is hindi siya makukonsidered na penalty kasi wala pang judgment na na-declare yung court. Kaya yung mga detention, fines, ganun, prior pa yon sa judgment ng court, so hindi mo siya makukonsidered na penalty. Kasi makukonsider mo lang yung isang bagay na punishment or penalty kapag decision yun ng court or kapag product yun ng judicial proceedings. Ganun. The arrest and temporary detention of an accused, therefore, during the pendency of the case by reason of the fact that his case is not bailable or that he could not afford to post bail is not considered a penalty. Such period of detention, however, may be credited in the service of his sentence. So, yung arrest or detention ng isang tao, guys, during the pendency of her case or habang ongoing pa yung case niya, guys, is hindi siya makukonsidered na penalty. However, kapag nag-render na ng judgment yung court, tapos pinatawan siya ng like sentence, yung detention na nalulong, yung detention or yung days or months or ano ba, is mai-include siya dun sa pag-count ng service ng kanyang sentence. So, ganun yon. So, example of deprivation of rights established in penal form. So, the deprivation of rights established in penal form by the civil laws is illustrated in the case of parents who are deprived of their parental authority if found guilty of the crime of corrupt of their minor children in accordance with Article 332 of the Civil Code, 332, Article 332 of the Civil Code. We will also make a video for that, for the Civil Code na mga provisions. Yun. So, again guys, yun lang sa Article 24 guys. It talks about preventive measures. So, yung mga na-state dito sa provision na to guys is hindi siya mako-considered na penalties. So, this ends my video guys. Thank you so much for watching. I hope you do like this video and don't forget to subscribe to my channel. Bye-bye!
Bye-bye!